The courtroom smelled like old paper and floor wax. Fluorescent lights buzzed overhead, casting a pale glow on the wooden benches and scuffed linoleum floor. It was just another Tuesday morning in County Courtroom 3. Routine, quiet, the kind of place where time seemed to slow down. People shuffled in and out. A tired-looking mom with a toddler on her hip. A man in a rumpled suit checking his watch. A bailiff sipping coffee from a paper cup. Nothing unusual. Then the boy walked in. He was young, maybe 15, but carried himself like someone who'd already seen too much. His clothes were clean but worn. A navy blazer 2 sizes too big, jeans with faint fraying at the knees, and sneakers that had clearly walked miles. He stood alone near the defendant's table, hands clasped in front of him, eyes fixed on the floor. No parent, no guardian, not even a friend. Just him, a thin file folder, and the weight of whatever brought him here. At the bench, Judge Eleanor Whitmore adjusted her glasses and glanced at the docket. People vs. Johnson, she read aloud, her voice crisp and measured. Shoplifting under $50. First offense. She looked up, expecting the usual. A scared kid, maybe tearful, maybe defiant, probably mumbling through a rehearsed apology. But this boy didn't look scared. Not exactly. He looked focused, like he was solving a puzzle only he could see. His public defender, a man named Mr. Delgado, finally hurried over, flipping through a manila folder he clearly hadn't opened until that morning. All right, kid, he said under his breath. Just say you're sorry, tell the judge you won't do it again. And we'll get you probation, easy. The boy nodded, but didn't speak. Judge Whitmore watched them. She'd been on the bench for 23 years. She'd seen hundreds of kids like this, lost, overlooked, slipping through the cracks. Sometimes she tried to reach them. Not with lectures, but with something softer, a human moment. She leaned forward slightly. Son, she said, her tone gentler now. Before we get into the details, let's play a little game. Truth or lie? A few people in the gallery shifted. It wasn't standard procedure, but Judge Whitmore was known for this. With nervous kids, she'd ask simple questions. I've never eaten pizza, or my dog can talk, just to get them to relax. It usually worked. The boy looked up. His eyes were sharp, calm. Truth or lie? He repeated. Yes, she said, offering a small smile. I'll say something. You tell me if it's true, or a lie. He nodded again. Okay. She thought for a second. All right. Here's one. If someone borrows your phone and refuses to give it back, that's just being rude, not stealing. Most kids would have guessed. Maybe said, lie, with a shrug, but this boy didn't hesitate. Actually, Your Honor, he said, voice clear and steady, under Section 31.3 of the Penal Code, that's considered theft by unlawful appropriation. Once the owner demands return and the borrower refuses, intent to deprive is established. It's not just rude, it's a Class C misdemeanor. Silence dropped like a curtain. The bailiff stopped mid-sip. Mr. Delgado's pen froze over his notepad. Even the court reporter paused, fingers hovering over the keys. Judge Whitmore blinked. Excuse me? The boy didn't flinch. The law says possession doesn't equal ownership. If I lend you my phone and you keep it against my will, you've committed theft. There's a 2019 appellate case on State v. Ruiz that confirmed this exact scenario. Now the judge sat back. Her eyebrows lifted. She studied him. The calm posture, the precise words, the way he held his ground without arrogance. This wasn't rehearsed. This wasn't luck. You've read the penal code? She asked. Yes, ma'am. All of it? Most of it. Plus the rules of civil and criminal procedure, and some federal statutes. A murmur rippled through the small crowd. Someone whispered, "Who is this kid?" Judge Whitmore felt a flicker of something unfamiliar. Curiosity, maybe even doubt. She'd assumed he was just another kid caught in a bad moment. But now she decided to test him. Just a little more. All right, she said, leaning in again, voice low but firm. What's the difference between assault and battery? Without blinking. Assault is the threat or attempt to cause harm, like raising a fist. Battery is actual physical contact. But in Texas, we combine them. Assault includes both the threat and the contact under Section 22R01. She raised an eyebrow. And if a police officer questions a minor without a parent present, does that automatically make the statement inadmissible? No, he said. Not automatically. It depends on whether the minor knowingly and voluntarily waived their rights. The courts look at age, education, whether they understood Miranda, and if there was coercion. In re JDP in 2020 clarified that. Now the judge was truly stunned. She'd thrown out questions that even first-year law students might fumble. Yet this boy, standing there in thrift store clothes, no lawyer prepping him, answered like he'd been studying case law over breakfast. Mr. Delgado finally spoke up, voice tinged with embarrassment. Your Honor, I didn't know his file didn't mention. It's okay, the judge said, holding up a hand. She looked back at the boy. How did you learn all this? He hesitated for the first time. His shoulders tensed slightly. My older brother. He got arrested 2 years ago. They said he confessed to something he didn't do. I started reading, watching court videos, trying to understand how it happened. His voice dropped. I wanted to help him. Something in his tone, the quiet pain beneath the facts, made the judge's chest tighten. She'd heard 1,000 sob stories in this courtroom, but this felt different, real, raw. She glanced at the shoplifting charge again. A notebook. $3.49. The kind of thing kids steal when they're desperate for school supplies but too proud to ask. She cleared her throat. All right, she said, but her voice was softer now. Let's take a short recess. The bailiff called, all rise, as she stepped down from the bench. But as she walked past the boy, she paused. Just for a second. You stay right here, she said quietly. We're not done. He nodded. Back in her chambers, Judge Whitmore poured herself a glass of water and sat heavily at her desk. Her mind raced. She'd played truth or lie to put a kid at ease, not to uncover a legal prodigy. But that's exactly what had happened. And now she had to ask herself, had she almost dismissed him? Judged him by his age, his clothes, the fact he was alone? She pulled up his file on the computer, scanned the school records, saw the notes. Disruptive in class. Argues with teachers. Refuses to follow instructions. Classic signs of a gifted kid in a system that didn't know what to do with him. She thought about the notebook. The brother in prison. The way he'd spoken, not to show off but because he knew. Outside, the courthouse hummed with ordinary life. But inside that small courtroom, something unusual had just happened. A moment of truth, both literal and deeper. Judge Whitmore took a deep breath. She wasn't sure what came next. But one thing was clear. She wouldn't be treating this like a routine case anymore. Because sometimes the person who looks like they need saving is the one who already knows how to fight. When court resumed, the air felt different. Not tense exactly, but charged like before a summer storm. The boy stood in the same spot, hands still clasped. But now people watched him differently. The bailiff didn't look away when he passed. The court reporter sat up straighter. Even Mr. Delgado, the public defender, had actually opened his file and was scribbling notes like he'd just woken up. Judge Whitmore returned to the bench with quiet purpose. She didn't smile this time. She looked at the boy the way you'd look at a puzzle you hadn't realized was missing half its pieces. All right, she said, voice steady. Let's continue our little game. Truth or lie? A few people in the back exchanged glances. This wasn't normal, but no one objected. She leaned forward slightly. Here's one. If you're under 18, the police can't question you without a parent present. The boy didn't rush. He thought for just a beat, like he was double-checking the law in his mind before speaking. That's a lie, Your Honor. A soft gasp came from the gallery. He went on, calm and clear. There's no federal or state law that says a parent has to be there during questioning. Police can talk to a minor alone, but if they're in custody and being interrogated, they still have to be read their Miranda rights. And if they ask for a parent or lawyer, questioning has to stop. Judge Whitmore nodded slowly. And if they don't ask, then anything they say can still be used against them, he said. Unless the court decides the confession wasn't voluntary. Age matters, but it's not automatic protection. She studied him. You sound like you've thought about this a lot. His eyes flickered just for a second toward the floor. Yeah, he said quietly. I have. She didn't press. Instead, she asked another question. Truth or lie, if someone threatens you online, that's not a real crime. Lie, he answered right away. Cyberstalking and online threats are covered under harassment laws. If it causes fear of bodily harm, it can be a Class A misdemeanor or even a felony depending on prior offenses. Now the prosecutor, a woman who'd been scrolling on her phone, looked up sharply. She'd been ready to breeze through this case with a quick plea deal. But now she was paying attention. Judge Whitmore wasn't done. "Last one," she said. "If you're arrested but never told why, the charges get thrown out automatically." The boy shook his head slightly. "Not automatically. The law says you have to be informed of the charges without unnecessary delay, usually at your first court appearance. But if they hold you for days without telling you why, that could violate due process. It depends on the facts." He paused, then added almost gently, "It's not about automatic rules, Your Honor, it's about fairness." That word, fairness, hung in the air, simple, heavy. Judge Whitmore sat back. She'd started this game to ease a nervous kid, but now it felt like something else, like she'd accidentally opened a door and found a whole world behind it. She turned to Mr. Delgado. "Counselor, did you know your client had this level of legal knowledge?" Mr. Delgado shifted in his seat. "No, Your Honor. His file just said first-time offender, minor theft. I assumed—" "You assumed," she finished for him. Not angry, just disappointed, she looked back at the boy. "How long have you been studying law?" "About 3 years," he said. "Since my brother got locked up. I read everything I could find. Court transcripts, law review articles, even old Supreme Court decisions. I watch trials online. I take notes. Why? Because the system got him wrong," he said, voice low but firm. "And I didn't want it to happen to anyone else I care about. No drama. No shouting. Just truth, plain and sharp." A man in the back row, a local reporter who'd come for a slow news day, closed his notebook slowly, then reopened it and started writing again. Judge Whitmore exhaled. She glanced at the clock. This wasn't just about a $3 notebook anymore. Something bigger was happening here. "All right," she said. "I'm going to do something unusual." She turned to the clerk. "Seal the record on this recess. No public comments." Then to the boy. "Wait here. Don't leave the courthouse." She stood. "We're taking another recess. 30 minutes. This time when she walked out, her steps were quicker. In her chambers, she called the juvenile court coordinator. "Pull everything you have on Johnson. School records, IQ testing, social services history, everything. And get me the file on his older brother's case now." While she waited, she stared out the window at the parking lot below. Kids like this didn't just appear out of nowhere. There was always a story. And usually it was one no one had bothered to listen to. 25 minutes later, a thick manila envelope landed on her desk. She flipped it open. The school reports were eye-opening. In 6th grade, he'd scored off the charts on a cognitive assessment, 162 on the Stanford Binet. The psychologist's note read, "Exceptional verbal reasoning, advanced abstract thinking, potential for profound academic achievement." But the next page told a different story. "Teacher comments, argues constantly, corrects adults, disruptive during lessons." One wrote, "Seems to think he knows more than the curriculum." He'd been moved to a behavioral support classroom, then labeled at risk. His mother, working 2 jobs, missed parent-teacher conferences. Social services flagged the home for educational neglect after he missed weeks of school. Turns out, he'd been caring for his younger sister while his mom worked nights and his brother was in jail. And the shoplifting. The store's security footage showed him asking the cashier if he could pay later. When they said no, he waited until the store was empty, took a single spiral notebook from the shelf, and left. No hiding it, no running, just taking what he needed. Judge Whitmore rubbed her temples. He wasn't a thief. He was a kid trying to survive. Then she opened the brother's file. Armed robbery. Pleaded guilty after a 3-hour interrogation. No lawyer present, no parent. Just a scared 19-year-old signing a confession because the detective said, "It'll go easier on you." But the boy, her defendant, hadn't given up. He'd spent years digging. And now he was standing in her courtroom, quoting case law like it was second nature. When she returned to the bench, the room was silent. Everyone knew something had shifted. She looked at the boy. "I've reviewed your records," she said. "And I owe you an apology." A murmur went through the room. Judges didn't apologize. "I assumed things about you," she continued, voice steady, "based on how you looked. How old you are. The charge on the docket. That was wrong." He didn't say, "It's okay." He just nodded like he understood that people made mistakes, even judges. She turned to the prosecutor. The people are dismissing this charge. With prejudice. The prosecutor blinked. Your Honor, the evidence is clear. The evidence shows a child in need. Judge Whitmore interrupted gently but firmly. Not a criminal. Case dismissed. Then she looked at Mr. Delgado. Contact the Bar Association. Find this young man a mentor. Someone who understands juvenile law and gifted education. I want him connected. Today. Mr. Delgado, wide-eyed, nodded fast. Yes, Your Honor. Finally, she turned back to the boy. You've got a gift, she said. But gifts need room to grow. Don't let anyone tell you you don't belong in the places you're meant to be. He swallowed hard. For the first time, his voice cracked just a little. Thank you, Your Honor. But then he took a breath and said something that surprised even her. There's something else. She raised an eyebrow. Go ahead. My brother's case. It wasn't right. I have documents. Witness statements, I think he was innocent. The courtroom went still. Judge Whitmore didn't promise anything. She couldn't. But she met his eyes and said, if you have evidence, you have the right to present it properly, legally. And if you need help doing that, you'll get it. He nodded, shoulders straightening. Not with hope, though there was that too, but with resolve. As he walked out of the courtroom a few minutes later, the reporter from the back row caught up to him near the water fountain. Hey, the man said gently, mind if I ask your name for the article? The boy hesitated, then shook his head. It's not about my name, he said. It's about what's fair. And with that, he pushed open the heavy courthouse doors and stepped into the sunlight. Still wearing that too-big blazer, still just a kid. But now someone who knew the law wasn't just something that happened to people. It was something you could use to protect, to fix, to fight back. And for the first time in a long time, he felt like maybe, just maybe, it could work for him too. Judge Whitmore didn't sleep much that night. The boy's words kept playing in her head, calm, precise, but heavy with something deeper than legal knowledge. It wasn't just about statutes or court procedure. It was about trust, about whether the system could ever see someone like him clearly, or if it would always mistake quiet intelligence for defiance, poverty for guilt. By morning, she'd made up her mind. She called the local legal aid office before her first hearing. I need someone who actually listens, she said. Not just another overworked intern. Someone who knows juvenile justice and who won't treat a kid like a case file. 2 hours later, a woman named Diane Reyes walked into the courthouse. She wasn't flashy. Mid-40s, gray streaks in her hair, carrying a canvas bag full of legal pads and dog-eared law books. She'd spent 15 years fighting wrongful convictions, mostly for people no one else would take on. When Judge Whitmore explained what happened, Diane didn't laugh. She didn't look skeptical. She just said, I'll meet him. They arranged to meet at the public library, the only place the boy said he felt safe. He showed up early, sitting at a corner table with a stack of printed court opinions and a notebook filled with neat handwriting. When Diane sat down, he didn't smile. But he didn't look away either. You're the lawyer? He asked. I'm the one who's going to help you, she said, if you'll let me. He studied her for a long moment, then nodded. Okay, he didn't waste time. He pulled out a folder, thick, organized, labeled with dates and case numbers. Inside were copies of police reports, a transcript of his brother's interrogation, and handwritten notes comparing it to legal standards. At the bottom was a letter from a former classmate of his brother's, a kid who'd been at the same party the night of the alleged robbery. The letter said the real suspect had bragged about it later, but no one had followed up. Diane flipped through it slowly. Her expression didn't change, but her fingers tightened slightly on the pages. You found all this yourself? Most of it, he said. The police report was public record. The letter. I tracked him down. He didn't want to talk at first. Said he was scared. But I showed him the law, how witness intimidation is a crime too. He finally agreed to write it. Diane looked up. You're 15. I'll be 16 next month, he corrected gently. She almost smiled. You know, most law students couldn't put together a motion this clean. I just want my brother home, he said. He's been in there for 2 years. For something he didn't do. Diane closed the folder. All right, here's what we're going to do. First, I file a formal motion to reopen the case based on new evidence. Second, I request an evidentiary hearing. Third, and this is important, you don't talk to anyone else about this. Not reporters, not friends, not even your mom until we're ready. The system doesn't like surprises. He nodded. I understand. Over the next few weeks, they met almost every day. Sometimes at the library, sometimes at a quiet diner after Diane's other cases. She taught him how to frame legal arguments properly, how to cite rules of evidence, how to anticipate the prosecutor's objections. He soaked it all in like dry ground after rain. But what surprised her most wasn't his memory or his logic. It was his patience. He never rushed, never got angry. He just kept asking, is this right? Is this fair? Meanwhile, word began to spread. Not loudly, but steadily. A judge dismissing a case after a kid quoted case law. A pro bono attorney taking on a closed conviction because of a teenager's research. People talked. Some called it inspiring. Others whispered it was a stunt. But the local paper ran a small piece. Teens' Legal Knowledge Sparks Review of Wrongful Conviction. The story caught the eye of a non-profit that worked on juvenile justice reform. They reached out to Diane, offered funding, offered experts. Suddenly, what started as one kid's quiet mission had grown into something bigger. Back in court, Judge Whitmore quietly cleared space on her docket. She knew the motion would land on her desk eventually, and when it did, she'd be ready. The day the motion was filed, the boy stood outside the courthouse again. This time his mother was with him, a tired woman with kind eyes and work-roughened hands. She hadn't said much during the meetings, but she'd started coming to everyone, sitting quietly in the back listening. He's always been like this, she told Diane once, voice soft. Even as a little boy, he'd ask why. 100 times a day. Teachers said he was difficult, but I knew he just needed answers. Now, as they waited for the clerk to accept the filing, she put a hand on her son's shoulder. You sure about this? He looked at her. I have to be. Inside, the motion was thick, 23 pages of legal argument, exhibits, and citations. It didn't scream injustice. It didn't beg. It laid out the facts, the law, and the gaps in the original case with cold, clear precision. At the end, it asked for one thing, a chance to be heard. The prosecutor's office didn't respond right away. They were used to motions from seasoned attorneys, not teenagers. But when they read it, even they couldn't ignore it. The new witness statement alone was enough to raise serious doubts. A week later, Judge Whitmore called both sides into her courtroom for a status hearing. No cameras, no crowd. Just the essentials. She looked at the prosecutor. Have you reviewed the motion? The prosecutor, a man who'd handled hundreds of convictions, shifted in his seat. We have, Your Honor, and we're not opposing a hearing at this time. A murmur went through the small group. That was as close to we might be wrong as the state ever got. Judge Whitmore nodded. Then we'll set an evidentiary hearing. 4 weeks from today, she turned to the boy and Diane. Be ready. This won't be easy. The state will push back. They'll question your witness. They'll say this is too late. But if you've got truth on your side, that's what courts are for. After the hearing, the boy didn't celebrate. He just walked out with his mother and Diane, the late afternoon sun casting long shadows on the sidewalk. You did it, his mother said, voice trembling. No, he said. We're just getting started. That night, he stayed up late in his room, a small space with textbooks stacked on milk crates and legal printouts taped to the walls. He reread the motion, checked every citation, made sure every I was dotted. He wasn't doing this for fame. He wasn't even doing it just for his brother anymore. He was doing it because he'd seen how easy it was for the system to miss people, to look at a black kid in a worn blazer and see a problem, not a person. And if he could use the law to fix even one piece of that, then maybe it was worth all the nights studying, all the times he'd been told to know his place. The next morning, Diane called with news. The witness, the one who wrote the letter, had gotten cold feet. Said he didn't want to testify. Said he was afraid of retaliation. The boy didn't panic. He thought for a long time. Then he said, what if I talk to him? Not as a lawyer. Just as someone who knows what it's like to be scared. Diane hesitated. It's risky, but fair, he said. He deserves to be heard. Not pressured, just understood. She looked at him, really looked, and saw not a child but someone who already carried the weight of justice in his bones. All right, she said, but I go with you. They found the witness at his job, a car wash on the edge of town. He was nervous, eyes darting, hands wet from soap and water, But when the boy spoke, calm, no demands, just, "I know you're scared, but my brother's life is on the line," something shifted. The young man wiped his hands on his apron, looked at the ground, then nodded. "Okay," he said. "I'll testify." Back in the car, Diane glanced at the boy. "You've got a gift for this." He shook his head. "It's not a gift. It's just seeing people." As they drove home, the city lights flickered on one by one. Somewhere inside a prison, his brother was counting days. Somewhere in a courthouse, a judge was preparing to listen. And right here, in this old sedan with a tired lawyer and a kid who refused to look away, hope was quietly taking root. Not loud, not flashy, just real. And sometimes that's enough to change everything. The morning of the evidentiary hearing, the courthouse felt different. Not louder, not more crowded, but heavier, like the air itself was holding its breath. People moved slower. Voices were quieter. Even the usual clatter of coffee cups and shuffling papers seemed hushed. The boy arrived early, dressed in the same thrift store blazer, but this time it was pressed. His hair was neat. His hands were steady. He didn't look like a kid playing lawyer. He looked like someone who belonged. Diane was already there, reviewing notes at a side table. She gave him a small nod. "You ready?" He took a deep breath. "As I'll ever be." Inside the courtroom, the prosecutor's team had grown. 2 assistants now sat beside the main attorney, stacks of files in front of them. They weren't taking this lightly anymore. Word had spread. This wasn't just a routine motion. It was a challenge to a conviction the state had long considered closed. Judge Whitmore entered promptly at 9. She didn't smile. She didn't need to. Her presence alone said everything. This matters. "State vs. Johnson," she announced, her voice clear and firm. "Motion to vacate conviction based on newly discovered evidence." "Counsel, you may proceed." Diane stood. She laid out the facts calmly, how the original case relied almost entirely on a confession obtained after 3 hours of questioning with no lawyer, no parent, and no breaks. How the detective had a history of aggressive tactics, and how just weeks ago, a key witness had come forward with a sworn statement, saying the real perpetrator had confessed to him at a party the night of the robbery. Then she called the witness to the stand. He was nervous, 20 years old, shoulders hunched, voice shaky at first. But when Diane asked him what happened that night, he straightened up slightly. "He came up to me laughing." The young man said, "Man, you won't believe what I just pulled off." Then he described the store, the layout, the cash register, even the clerk's tattoo. Said he used a fake gun from a Halloween store. I didn't think much of it then. But after I heard who they arrested, I knew it wasn't right. The prosecutor stood for cross-examination. "You waited 2 years to say anything. Why?" "Because I was scared," the witness admitted. "I didn't want trouble. But then I saw this kid," he nodded toward the boy, "showing up at my job, not asking for favors, just saying, 'My brother's innocent.' And I realized staying quiet was worse." The prosecutor pressed harder. "Isn't it possible you're making this up now to help a friend?" "No," the witness said firmly. "I've got nothing to gain. I could lose my job, my apartment, but I couldn't live with myself if I didn't speak up." When he stepped down, the room was silent. Then Diane did something unexpected. "Your Honor," she said, "we'd like to call one more witness. Not to testify about the crime, but about the interrogation." Judge Whitmore raised an eyebrow. "Who?" "The defendant's younger brother." A ripple went through the courtroom. The prosecutor objected immediately. "Your Honor, he's a minor. He wasn't present during the interrogation." "This is irrelevant," but Diane stood her ground. "He's not testifying about the crime. He's testifying about what happened after. How his brother came home that night shaken, saying the police wouldn't let him leave until he signed something. And how for weeks he couldn't sleep. That goes to the voluntariness of the confession." Judge Whitmore thought for a long moment. Then she looked at the boy. "Do you understand the oath? That you must tell the truth, nothing but the truth?" "Yes, Your Honor," he said. "Then you may take the stand." He walked slowly to the witness chair, sat down, placed his hands in his lap. Didn't fidget. Didn't look away. Diane asked gentle questions. "What happened the night your brother was questioned?" "He came home around 2 a.m., the boy said. His eyes were red. He kept pacing. "He told me the detective said if he didn't sign, they'd charge him with more crimes. Say he had a real gun, that he hurt someone." He said he just wanted it to stop. Did he understand his rights? He said they read them fast, like a script. Then they kept talking over him when he tried to ask questions. Diane paused. Why did you start studying law? Because I saw how easy it was for someone to get lost, he said. My brother didn't yell. He didn't fight. He just gave in, and no one checked if that was okay. The prosecutor stood for cross. He tried to rattle him. You're not a lawyer. You're 15. How can you possibly understand police procedure? The boy didn't flinch. I read the law. I watched real interrogations. I compared them to what happened to my brother. The difference was clear. You're biased, the prosecutor said sharply. Yes, the boy admitted. I love my brother. But that doesn't make the facts wrong. Something in the way he said it, not defensive, not angry, just honest, made even the prosecutor pause. When he stepped down, Judge Whitmore didn't announce a ruling right away. She said she'd take the matter under advisement. But as she left the bench, she gave the boy a look. Not pity, not praise, but respect. Outside reporters waited. Cameras clicked. But the boy didn't stop for interviews. He walked straight to his mother, who stood near the courthouse steps, tears in her eyes. You were so brave, she whispered. I just told the truth, he said. Over the next few days, the legal community buzzed. Law professors cited the hearing in class. Public defenders shared the transcript with their teams. Even the state's own internal affairs unit quietly opened a file on the detective involved. Then, 10 days later, Judge Whitmore issued her ruling. She didn't just grant the motion, she dismantled the original conviction piece by piece. She wrote that the confession was obtained under conditions that undermined its reliability, that the new witness testimony was credible and material, and that justice demands a second look when truth knocks on the courthouse door. The conviction was vacated, all charges dismissed. That afternoon, his brother walked out of prison a free man. They met in the parking lot of a bus station. No fanfare, no cameras. Just two brothers hugging like they hadn't seen each other in years, because they hadn't. The older one kept saying, I'm sorry, over and over. The younger one just held on tight. Later, at a small diner, the family sat together for the first time in 2 years. His brother looked thinner, older, but his eyes were lighter. You did this, he said, shaking his head. You never gave up. I couldn't, the boy said simply. But the story didn't end there. Within weeks, the district attorney's office announced a review of all cases handled by that detective over the past 5 years. 3 other convictions were flagged for possible misconduct. One man had already served 18 months for a crime surveillance footage later proved he didn't commit. And the boy? He kept studying, but now others were watching. A retired judge offered to tutor him. A law school dean invited him to sit in on a constitutional law seminar. A nonprofit asked if he'd help design a workshop for teens on knowing their rights. He said yes to all of it, but with one condition. I don't want to be a prodigy or a phenomenon, he told Diane. I just want kids like me to know they're not invisible. So they started small. Saturday mornings at the community center. He'd bring printouts of the Bill of Rights, explain Miranda in plain English, show them how to ask for a lawyer without sounding rude. Kids came, some skeptical, some scared, some just curious. But they stayed. Because he didn't talk down to them, he talked with them. One girl asked, what if the officer doesn't listen? Then you stay calm, he said. You say it again. And you remember every detail, because someone somewhere might be waiting to hear you. Judge Whitmore came to one of those sessions. She sat in the back, arms crossed, listening. When it was over, she walked up to him. You're building something important, she said. He shrugged. Just trying to fix what's broken. She smiled faintly. That's how real change starts. As summer turned to fall, the boy turned 16. No big party. Just a quiet dinner with his family and Diane. But that night he stayed up late again, not studying case law but drafting a letter. It was to the State Bar Association. He was applying for a special youth fellowship, not because he wanted to be a lawyer someday, though he did, but because he believed the law shouldn't be a secret language only the powerful understand. It should belong to everyone, and if he had to be the one to hand out the keys, then so be it. Winter came early that year. with a cold wind that rattled the courthouse windows and sent people pulling their coats tighter as they hurried down the street. But inside the community center on Elm Street, it was warm, both from the old radiator humming in the corner and from the quiet energy of a dozen teenagers gathered around folding tables, notebooks open, pens moving. At the front of the room stood the boy, no longer just a defendant, no longer just a brother fighting for justice. Now he was a teacher, not in title but in action. Every Saturday morning he showed up with printed handouts, real court rulings simplified into plain English, and stories that didn't sugarcoat the system but didn't scare kids away from it either. Knowing your rights isn't about being defiant, he'd say, leaning against the whiteboard. It's about being seen, about making sure no one gets to decide your story before you've had a chance to tell it. The kids listened, not because he was older, he barely was, but because he'd been where they were. He knew what it felt like to be talked over, looked through, assumed guilty before asked a single question. One Saturday, a girl raised her hand. "What if you're scared to speak up?" He didn't give a lecture. He just nodded. "Then you write it down, or tell a friend, or call a hotline. Fear doesn't make you weak, but silence can let wrong things keep happening." After the session, Diane found him packing up his materials. "You're getting good at this," she said. "I'm just saying what I wish someone had told me," he replied. Zipping his bag, he'd turned down the scholarship offers, the fancy prep schools, the summer law camps with glossy brochures, not because he didn't appreciate them, but because he didn't want to leave. "If I go somewhere that only sees me as exceptional," he'd told Diane, "I might forget the kids who get called trouble just for asking questions." So he stayed, and built something real instead. With help from the nonprofit and a retired public defender who'd heard about his work, they launched the Know Your Rights youth program. It started in one room. Now it ran in 3 neighborhoods. They taught kids how to record police encounters safely, how to request a lawyer without escalating tension, how to read a court summons. No jargon, no fluff. Just truth served plainly. Meanwhile, Judge Whitmore had changed too. She stopped playing truth or lie in court, not because it was wrong, but because she realized she didn't need games to see people. She started asking different questions. Do you understand what's happening? Is there someone you trust who can help you? What do you need right now? Other judges noticed. Some mocked her at first, but when her courtroom saw fewer appeals, fewer misunderstandings, even fewer repeat appearances, they started listening. One afternoon, she called the boy into her chambers, not for a case, but for a conversation. "I've been thinking," she said, handing him a thick envelope. "There's a new policy being drafted for juvenile intake. They want someone who's actually been through it to help shape it." He opened the envelope. Inside was an invitation to join a state task force, alongside lawyers, social workers, and judges, to redesign how young people are treated the first time they enter the system. He looked up, surprised. "Me? You," she said. "Because you didn't just survive the system. You showed us where it's blind," he accepted. Not for the title, but for the chance to make sure no kid had to memorize the penal code just to be heard. As the months passed, his brother found steady work, not easy, with a record still hanging in the air, even if the conviction was gone, but he showed up every day, head high. At night, he'd sit with his younger brother, helping him proofread legal summaries for the youth program, proud in a way that didn't need words. Then came the letter. It arrived on a Tuesday. Thick paper, official seal. The boy opened it at the kitchen table while his mom made tea. It was from the state bar. Not about a fellowship this time, but an invitation to sit for the LSAT as part of a special access program for self-taught legal learners. He wasn't old enough to apply to law school yet, but they wanted to test his readiness, and they wanted to use his journey to create a path for others like him. He read it twice, then folded it carefully and put it in his desk drawer, next to his brother's release papers and the first notebook he'd ever taken from that store. That weekend, at the community center, a new kid showed up, maybe 14, hoodie pulled low, eyes wary. He sat in the back, arms crossed, like he expected to be told to leave. The boy didn't call him out. He just started the session like usual. Halfway through, he asked the group, "What's one thing you wish adults understood about you?" Hands went up. Answers came, that I'm trying, that I'm not lazy, I'm tired, that I notice when you don't believe me. When it got to the new kid, he hesitated, then mumbled that I'm not stupid just because I talk different. The room went quiet for a beat. Then the boy nodded. You're not, and neither was I. After class, the kid lingered. You really read all that law stuff? By yourself? Yeah, the boy said, because no one was going to do it for me. The kid looked down, then back up. Think I could learn some of it too? Everyone can, the boy said. You just got to start. Later that evening, Judge Whitmore stood on the courthouse steps after a long day. The sun was setting, painting the sky in soft oranges and purples. She saw him walking down the sidewalk, backpack slung over one shoulder, heading toward the bus stop. She called out, Hey. He turned. She walked over. I heard about the LSAT letter. He shrugged. It's just a test. It's more than that, she said. It's proof that brilliance doesn't always wear a suit. Sometimes it wears a thrift store blazer and shows up alone in court. He smiled. A real one. Small but warm. She paused, then said something she'd never said to anyone before. You changed how I see my job. He looked at her. Really looked. You chose to look again. That's what justice should be. She nodded. Didn't say anything else. Didn't need to. As he walked away, she watched him go. Not as a judge watching a former defendant, but as one person honoring another who refused to be invisible. Back home, the boy sat at his desk under a single lamp. He opened a fresh notebook. At the top of the page, he wrote, Public Defender's Handbook for Teens, Draft 1. He wasn't dreaming of fame. He wasn't chasing headlines. He just wanted to build a world where a kid didn't have to be a legal genius to get a fair shot, where being smart didn't mean being labeled difficult, where truth didn't need a game to be heard. Outside, the wind howled, but inside there was quiet focus, the kind that builds futures, one honest word at a time. And somewhere in a courtroom not yet built, a younger kid would one day stand seen, prepared and unafraid, because someone like him had paved the way. It had been 2 years since that first morning. In County Courtroom 3, the day a judge played a game with a quiet kid in a too big blazer and accidentally uncovered a mind that refused to be ignored. Now the courthouse still smelled like old paper and floor wax, but something deeper had changed. Not in the building, but in the people who walked through its doors. The boy, no longer just a boy but not quite a man yet either, sat in the back row of a different courtroom on a rainy Thursday afternoon. He wasn't on trial. He wasn't even a witness. He was there as an observer, notebook open, pen ready. Beside him sat a group of high school students from the youth legal literacy program he'd helped build. They'd come to watch a real motion hearing, not the kind on TV with shouting and dramatic reveals, but the slow, careful work of justice being done right. One of the students leaned over. Is it always this? Quiet, he smiled. Most of the time, yeah. The big moments happen in the details. The wording of a sentence, the timing of an objection, the way someone tells their truth without flinching. Up front, a young public defender stood arguing for a client's bail reduction. She wasn't flashy. She didn't raise her voice. But she cited the right statute, referenced the client's steady job and clean record, and reminded the judge that pretrial detention shouldn't be punishment. The judge listened, asked questions, then granted the motion. Afterward, as they walked out into the drizzle, one of the students said, She didn't win with drama. She won with facts. Exactly, he said. That's the real power. He wasn't in school full-time anymore, not in the traditional sense. He'd enrolled in a hybrid program that let him take college-level courses while continuing his community work. His LSAT score had stunned even the admissions counselors, so high they called to double-check it wasn't a mistake. But he'd turned down early admission offers. I'm not ready to leave the work here, he'd told Diane. There's still too much to fix. And there was. The detective whose tactics had sent his brother to prison was no longer on the force. Internal Affairs had found a pattern of coerced confessions across a dozen cases. 2 more convictions had been overturned. One man, after serving 3 years, now ran a mentorship program for at-risk teens. He'd thanked the boy in person, not with grand words, but with a firm handshake and a quiet, "You gave me back my life." But the real change wasn't just in courtrooms. It was in classrooms. The Know Your Rights program had grown into a citywide initiative. Teachers invited the team to speak. Principals asked for workshops on student rights during school searches. Even the local police department, after some resistance, agreed to let officers sit in on sessions to hear directly from young people about what respect really meant. One afternoon, the boy found himself standing in a high school auditorium not as a guest, but as a co-facilitator with a veteran officer who'd once been skeptical. The officer spoke first. "I used to think if you knew your rights, you were hiding something. Now I know. You're just protecting your dignity." Then the boy stepped up. He didn't talk about case law. He talked about his brother, about fear, about how silence can feel safer than speaking up until it isn't. Afterward, a girl stayed behind. She was maybe 15, eyes red like she'd been crying. "My little brother got picked up last week," she whispered. "They said he stole a bike, but he was just riding it. He borrowed it from a friend." No one listened. He didn't offer empty comfort. He handed her a card with the legal aid hotline. "Call this. Say you're with the youth program. They'll help you file a motion for a hearing. And bring your friend, the one who lent the bike. Witnesses matter." She nodded, clutching the card like it was a lifeline. That night, he sat at his kitchen table with his brother, going over a draft of a new guide. What to do if you're questioned by police for teens. His brother read it aloud, marking places where the language was too formal. "Say you have the right to stay quiet instead of, you may invoke your right to remain silent," he suggested. "Keep it real." They laughed a little, something they hadn't done much of during those long prison years. Later, Diane called. "The state task force wants to pilot your intake protocol in 3 more counties. They're calling it the Fair Start model." He leaned back in his chair. "As long as it's not named after me." "It's not," she said, "but everyone knows where it came from." He didn't care about credit. He cared about results, and the numbers were starting to show it. Fewer kids held in detention for minor offenses, more connected to counselors instead of cells, more families understanding their rights before they ever stepped into a courtroom. One Saturday, Judge Whitmore showed up at the community center, not in robes, just a coat and scarf, holding 2 paper cups of hot chocolate. She sat in the back during a session on how to read a court summons. When it was over, she walked up to him. "You've built something that lasts," she said. "I didn't build it alone," he replied. "No," she agreed. "But you lit the match." She paused, then added, "I'm retiring next year." He looked at her, surprised. "Why?" "Because I've seen what's possible," she said. "And I don't want to be the kind of judge who stays too long and forgets how to change." He understood. Some people hold on to power, others pass it on. As spring arrived, the boy received an unexpected invitation. Not from a law school, but from a national youth justice coalition. They wanted him to speak at a conference in Washington, D.C., not as a prodigy, but as a practitioner. The title of his talk? "Justice Isn't a Spectator Sport." He almost said no. He hated the spotlight, but then he thought of all the kids who'd told him, "I didn't know I could do that," after seeing him argue in court or lead a workshop. So he went. He didn't wear a suit. Just a clean button-down and the same quiet confidence that had once stunned a courtroom. When he spoke, he didn't quote famous judges or cite landmark cases. He told stories about his brother's hands shaking after the interrogation, about the first kid who came back to the program and said, "I used what you taught me," and they listened, about the moment he realized the law wasn't just a shield. It could be a tool to build something better. Afterward, people lined up to talk to him. Not for autographs, but for advice. A teacher from Chicago asked how to start a similar program. A public defender from Texas wanted help training her interns to work with gifted but overlooked youth. A teenager from Atlanta just said, "You make me believe I belong in law school." On the flight home, he looked out the window at the clouds below. He thought about how far he'd come, not in miles, but in moments. The moment he took that notebook. The moment he spoke up in court. The moment he chose to stay and teach instead of leave and chase prestige. He wasn't done, not even close. Back in his city, the work continued. New faces came through the program every week. Some were scared. Some were angry. Some just wanted to understand why the world treated them like problems instead of people. And every Saturday, he was there, answering questions, correcting misconceptions, reminding them that their voice mattered, even if it shook. One evening, as he locked up the community center, his phone buzzed. It was a text from his brother. "Mom's making your favorite. You coming home for dinner?" He smiled. Typed back, "On my way." The streetlights flickered on as he walked, hands in his pockets, the cool air sharp in his lungs. He passed a bus stop where a kid sat alone, head down, looking like he carried the weight of the world. The boy slowed, then stopped. "Hey," he said gently. "You okay?" The kid looked up, wary at first, but something in the other's eyes, no judgment, just care, made him relax a little. "Just had a rough day at school," he mumbled. "Want to talk about it?" the boy asked. "Or just sit for a minute?" The kid hesitated, then nodded. They sat on the bench together under the amber.